Good morning and welcome to our webinar this morning. We are very excited to present to you Mr. Kevin Johnson. He's the founding shareholder of Johnson Jackson, a Tampa law firm that specializes in management side of labor and employment law. Kevin graduated from the University of Florida, go Gators, and he's been board certified by the Florida Bar in labor and employment law since 2007. He has been named to the super lawyers list of the top 100 lawyers in Florida 11 times. He's a past chair of the Florida Bar Civil Procedure Rules Committee, in addition to several other Florida Bar committees, and he's also the past president of the Tampa Bay chapter of the Federal Bar Association. Kevin has litigated cases in courts throughout the United States and truly enjoys helping employers work through these challenging issues. From a personal perspective, we are so grateful for Kevin's very direct and very passionate engagement with the Florida Restaurant and Lodging Association and its members. And we have come to rely on his very wise and sage counsel, especially when rules like this come out. So it is absolutely my pleasure and privilege to introduce to you and turn the floor over to Mr. Kevin Johnson. Good morning, Kevin. It's all yours.
Good morning, Samantha, and thank you for that wonderful introduction. Welcome to all of our attendees. This is going to be a fun webinar today because this marks the end, not necessarily the end, but at least the start of the end, we think, of the 80-20 rule, which is something that the restaurant industry has had to contend with for probably 25 or 30 years. It's been something I've been fighting against my whole career, and now we're at the point where there's a chance that it may actually be dead. So let's talk a little bit about what our agenda is today and what we're going to cover during this webinar. We're going to start out by talking about the background of the 80-20 rule, what it was and how it came to be. We'll then talk about what the Fifth Circuit did in the recent opinion, and then we'll talk about where the Department of Labor will go from here and what their options are. And finally, we'll discuss the practical consequences of this for Florida employers. So let's jump right into it. So the 80-20 rule is something that grew out of the Fair Labor Standards Act. And the Fair Labor Standards Act doesn't mention anything about a percentage. What it says is that you can have a sub-minimum wage that you can use to pay tipped employees. That came about in amendments in 1966. And that's when this definition in 203M was added, and that defines what the sub-minimum wage is. And in Florida, it amounts to a tip credit of $3.02 because of the way state law interacts with federal law. In Section 203T of the Federal Fair Labor Standards Act, there is a definition of what a tipped employee is. And it says that a tipped employee means any employee engaged in an occupation in which he customarily and regularly receives more than $30 a month in tips. The way that courts have traditionally interpreted this means that the occupation itself must be one that is customarily understood to receive tips. We can't just suddenly decide we're going to pay kitchen folk, $30 a month in tips and somehow make them tipped employees because they don't have a custom and tradition of being tipped. But that's the definition that we've had for years under the Federal Fair Labor Standards Act. So how did we get a 20% limitation out of this? Here's how it came about. In 1967, shortly after that tip credit was added, the Department of Labor issued some regulations, and one of them was what was called the dual jobs regulation. And that said that, look, if you are employed for an employer, you really have two jobs. Like, for example, you are a waiter most of the time, but you also work as a maintenance person, then you can only have the tip credit applied to your wages for the work that you do as a waiter. And so this is the example that the Department of Labor gave. They said in that case, that person is employed in two occupations, and you can't use the tip credit for the second occupation. And here's the line that caused us all the trouble. Such a situation is distinguishable from that of a waitress who spends part of her time cleaning and setting tables, toasting bread, making coffee, and occasionally washing dishes or glasses. And you can see what they were trying to do if you read that with common sense. They were trying to say that just because a server has some occasional duties that may resemble things that you might otherwise have other occupations do, You might have a dishwasher who washes most of your glassware. Just because a server occasionally touches a glass doesn't mean they suddenly became a dishwasher, right? And just because someone occasionally cleans and sets tables doesn't automatically turn that server into a busboy. Well, the Department of Labor was fine if they had stopped there, but of course they didn't. What they did was they decided that you needed to then go into that regulation and you needed to define what it meant to work part of the time and occasionally, right? Because they thought that there would be a problem if employers were allowed to say that you could have your servers get the tip credit rate for time that they spent cleaning and setting tables or toasting bread or making coffee. And apparently they thought we were suddenly going to convert our servers into cooks or janitors or bussers, probably forgetting for the fact that you still have to have somebody to actually serve the customers at the tables. So that's not in our incentive. That's not what we would do as an industry. But nevertheless, the Department of Labor thought there's a need for another bit of guidance. And this time they did not go back and issue a new regulation. Instead, they issued what is called sub-regulatory guidance. So let's kind of break down what that means, because that's helpful to understand what has happened. When you look at the levels of authority that are under federal law, the laws that Congress passes are called statutes, and that controls how a court rules. Then, when an agency is charged with helping to administer a statute, it can issue regulations that help to explain the statute. Regulation is typically subject to notice and comment rulemaking, where everybody who's interested can put in their 2 cents, and the agency has to account for that and then issue a final regulation. But without going through notice and comment rulemaking, the agency can also issue guidance at a lower level through things like opinion letters, or in this case, an internal handbook. And that doesn't get subject to notice and comment rulemaking. And because it's at a lower level, it traditionally has gotten less deference from the courts. Courts listened to it, but wouldn't necessarily defer to it to the same degree they would a regulation that had gone through notice and comment rulemaking. So what happened with this 80-20 rule? Well, we started out in 1966 with this amendment to provide the tip credit wage. In 1967, the dual jobs regulation was issued. Then in the 1970s through the mid-80s, there was a series of opinion letters that came out. Again, sub-regulatory, kind of low-level stuff that really hadn't gotten vetted by anyone other than the agency itself. And so in 1988, the agency put out an internal handbook for its investigators called the Field Operations Handbook that expressly said it wasn't supposed to provide interpretive guidance for courts. It was just kind of for internal use to tell their investigators how to investigate cases. And in there, they had a statement basically trying to collect and summarize all of these opinion letters that they'd put out. And they said, for their purposes, when they were doing an investigation, so long as that work that wasn't tip producing was less than 20% of the work week, it was fine. But if it exceeded 20% of the work week, then you couldn't take the tip credit wage and apply it to that. And so that was a change, right? That was something where for the first time we had something we really had to pay attention in the industry. But again, it wasn't supposed to be an actual high-level regulation. This is just internal guidance. Well, what happened is the plaintiff's lawyers got a hold of it and they started citing it in cases. So then when those cases reached the appellate level in the circuit courts, sometimes the Department of Labor would chip in. They would volunteer to write what's called an amicus brief, where they basically offer their opinion of how the statute should work to the appellate court. And they started supporting this rule and making it their official policy through a series of briefs in the U.S. circuit courts. And so that became even more problematic for the industry. So now we have the DOL really getting behind this position that started out at a fairly low level. And so we started getting some serious appellate court decisions on this. And it began with something out of the Eighth Circuit. That's this light blue area that you can see right here in the middle of the country. And they had a decision called FAST in 2011 that came out and basically said, look, the Department of Labor had the authority to issue this dual jobs regulation. And we're going to give them deference for that. And then, below that, they have issued these opinion letters and they've taken a position in briefs that this is how it should work. And we're going to give a different kind of deference to that. And so therefore, we're going to buy what the DOL is selling and we're going to get behind the 80-20 rule. And then in the Ninth Circuit in 2018, we had a temporary victory before a 3-judge panel, which said, no, that's not how it should work. That's inconsistent with the statute. But ultimately, the whole Ninth Circuit, or at least a larger panel with 10 or 12 judges, took a second bite at the apple and supported the Department of Labor's position. So now you had 2 circuit courts lined up behind the 80-20 rule. And then in 2021, it went to our circuit, which is Georgia, Alabama, and Florida, the 11th Circuit. And in a case called Rafferty, once again, they looked at some of what the Department of Labor was doing at the regulatory level and ultimately decided they were going to support the 80-20 rule also. So we have 3 problematic circuit court opinions out there that have caused us problems. And that's why everybody was kind of accepting that we were going to have to live with this. Well, then we had some changes come our way. In 2018, after Trump took office, his Department of Labor revised the Field Operations Handbook and said, we're not going to do it that way any longer. And then when the courts refused to accept that, they then said, well, if that's the case, we'll go amend the dual jobs regulation itself. And we'll say that, look, the focus really needs to be on the occupation. And so long as the duties are in the occupation, and you perform them contemporaneously with the rest of the tip producing duties, then there shouldn't be a temporal limit on how often you can perform them. Well, that was scheduled to go into effect in 2021, right after, right as the start of the next term was going to happen. So of course, Trump lost, and then the Biden administration came in and they extended the effective date of that. So that proposed amendment to the regulation never took effect. Instead, the Biden Department of Labor issued a new final rule and changed back to the old way of doing things. So we have the 80-20 rule, but now we have this totally brand new 30-minute limitation that came out of thin air and got added by the Biden Department of Labor in this 2021 regulation. And that's what's referred to in the opinion as the final rule. So when it went into effect, it was challenged, right? But let's talk before we get to that about what its operation really was and how it worked. It basically divided time up into 3 buckets. We had tipped work, which could always be paid using the tip credit rate. And that's the type of work that took place at the table side, what the Department of Labor considered to be customer interaction that produced tips. We then had on the other side in the blue bucket, what the Department of Labor considered to be unrelated duties, things that were part of a different occupation altogether, such as cleaning hoods in the kitchen or doing, cooking in the kitchen or cleaning bathrooms, which they considered to be unrelated to the duty of a server, and unrelated to that occupation, and therefore wasn't eligible to be paid for the tip credit rate at all, no matter how much of it you performed or how little of it you performed. If it was an unrelated duty, it had to be paid at full minimum wage. In the middle, in the yellow bucket, they had what they called related duties. And the related duties were what we typically thought of as side work, And they had some interesting, statements in their guidance here with this new regulation. They said things like, well, if you go back to pull a bottle of wine for a customer at the customer's request, that would be tipped work and it would fall in the red bucket. But if you do it as part of a pre-shift restocking of the bar, then it's a related duty and it's subject to these limitations. Well, that all made it very, very difficult, right? So what were the limitations? The limitations themselves were 3 key ones. Like we said, if it was unrelated work in a non-tipped occupation, you could not pay it at the tip credit rate at all. But if it was in that yellow bucket, then it was a related duty and it couldn't exceed 20% of the work week. Or if it was related work, it also could not exceed 30 consecutive minutes. So if I'm sitting there rolling silver and maybe I'm dawdling a little bit and it should take me 20 minutes to roll the silver, but I spend so much time looking at my phone and texting it takes me 35 minutes. Well, now that has become work that's no longer eligible to be paid at the tip credit rate. And so it made it very, very difficult for all of us to administer that rule. So what happened is that the Restaurant Law Center and the Texas Restaurant Association went to court and filed suit in a district court in Texas and argued that this new rule violated what's called the Administrative Procedures Act. And the APA, as it's known, says that courts have to hold unlawful and set aside any agency actions that are arbitrary, capricious, abuse of discretion, or otherwise not in accordance with the law. And so at the district court level, they lost initially. And it went up to the appellate court level on whether they should have an injunction. The Fifth Circuit sent it back and said the district court should have considered giving an injunction against it. Meanwhile, when it went back to the district court said, you know what, we don't need an injunction because I'm just going to rule in favor of the Department of Labor on summary judgment. And I find that all of this is within the Department of Labor's power and the rule itself is fine. Okay, so then the Restaurant Law Center and the Texas Restaurant Association took an appeal. And it got up to the Fifth Circuit, and the Fifth Circuit took a hard look at it. Here's what was different. Previous courts that we talked about had deferred to the Department of Labor's interpretation of the statute under something called Chevron deference. It was a doctrine that said that if the agency had the ability and was given the ability by Congress to interpret the statute, and there was a part of the statute that was ambiguous, then the court had to defer to any reasonable agency interpretation of that statute. There was a lot of controversy over it, and it recently was ended by the Supreme Court. And so when it got to the Fifth Circuit this time, this striking of the Chevron deference occurred midway through the appeal, actually after they'd already had their oral arguments. But what it meant was the Fifth Circuit was free to review whether the regulation was in accordance with the statute without having to give the DOL's view deference. And that made a difference, okay? The argument focused on whether the Department of Labor's regulation was the proper interpretation of the statutory phrase engaged in an occupation. Because remember how we said the rate could be applied to any work that you did when you were engaged in an occupation that was traditionally tipped? Well, the court looked at it and said, well, if you apply the dictionary definition of that, that basically means you should be focused on whether the person was engaged in that particular job, whether they were employed in a job. And so the focus should be on the field of work and the job as a whole. There's no need to delve down into specific tasks. And the court noted that, look, the FLSA doesn't really ask whether the duties that make up this occupation are themselves each individually capable of producing tips. They just said, is the occupation itself traditionally one in which you receive $30 or more a month in tips? And because that was all that the DOL should have asked, it had gone too far. And so the court held that the final rule was applying the tip credit in a manner inconsistent with the FLSA's text. And if that wasn't enough, they then went further. They found that even if you looked at it the way the Department of Labor looked at it, as whether they had engaged in appropriate line drawing, that the regulation was also what they call arbitrary and capricious. That basically means it was interpreted and put together in a way that Congress would not have found acceptable. It's not something that was within what Congress contemplated. And they said the reason that it's arbitrary and capricious is because you've taken away the focus on the occupation and you've replaced that with the timesheet. You said all that matters to the DOL is how much time you spend on these duties and whether they are tip producing. And that's inconsistent with the text of the statute itself, which is what we're supposed to be looking at, which focuses on whether it's part of the occupation. Because it was unlawful under the APA, the Fifth Circuit vacated it. That means that that rule no longer has any legal force. So this new final rule that came out in 2021 is now basically of no moment. If you go and look it up on Westlaw, it will say that it's been vacated by this Fifth Circuit opinion and it no longer has the force of law. So where is DOL going to go from here? They've got some options, right? One of the things they could do is, because this was a 3-judge panel of the Fifth Circuit, they could seek a rehearing. It's what's called rehearing en banc, when you ask all of the judges on the Fifth Circuit to take a look at this and sit as a whole to review what the panel said. And, that's one possibility here. The Fifth Circuit is one of the most conservative circuits here. And, in this case, this was a unanimous opinion from this three-judge panel. And even a judge here who had traditionally kind of been a more liberal judge went along with this. They couldn't even get that judge's vote. So that might make the DOL wonder whether they've got a chance in front of the rest of this conservative circuit. They could theoretically try to seek review from the Supreme Court. But here's where it gets tricky. When the Department of Labor goes into battle in the appellate courts, the attorneys who represent it are called the Solicitor General's office. And the Solicitor General is the agency or the entity that represents all of the federal government's agencies whenever they're trying to litigate in federal court. And so the Solicitor General has to be convinced that this is a worthwhile use of its time. And the Solicitor General might look at this and say, well, DOL, you couldn't win before the appellate court. What makes you think we can win this before a Supreme Court that itself seems very conservative right now? And so there's a chance that it might not even get to the Department of Labor to the Supreme Court, if the Solicitor General doesn't want to go along with what DOL is asking it to do. So that's kind of the internal inside politics of this. Well, if the DOL can't win at the Fifth Circuit and isn't able to get review from the Supreme Court, or can't win at the Supreme Court, then their options are pretty limited. They're down to, they can either go through this whole process again, they can try to redraft the regulation itself in a way that focuses on the occupation and makes more sense and is more likely to get through the Fifth Circuit, or it can try to convince Congress to amend the statute itself. Now, for that to happen, as a practical matter, you would probably have to have Harris win the election. You would have to have Democrats control both houses of Congress. I don't know what the likelihood of that is, but even if that happens, you then have to question whether that's something that the administration is going to want to spend its time on to basically reverse something that it's already been told makes very little sense by the courts. And it would be up to us as an industry to apply as much pressure as we can, if that seems to be in the works, to try to point out just how problematic all this was and just how nonsensical it was. But those are the options for the Department of Labor. So and I've talked about this over the weekend, actually, with Paul DeCamp, who is the actual attorney at Epstein Becker, who won this case out in front of the Fifth Circuit. We had a good conversation. His view on it is, look, the Fifth Circuit is not likely to change their mind about this. They're not likely to grant a rehearing en banc. And even if they did, they would probably just rubber stamp this decision. And he thinks the Solicitor General is really going to be leery of taking this forward to the Supreme Court. So that means that what we have right now is a Fifth Circuit opinion that says that this new expression of the rule is gone, right? And so that leaves the question of, where are we as employers now, right? What should we do going forward? Is this really dead? Here's how I would break it down. The 30-minute rule is definitely dead, because that was a creature of this 2021 regulation. It never appeared anywhere else before. No court has ever upheld it. And I've even, in the conversation I just had with the plaintiff's lawyer, he agrees the 30-minute rule is dead. Okay, so I don't think we have to worry about that anymore. But what about the 20% limitation on the related duties? Well, we no longer have a regulation that says we have to observe that, but there are these prior circuit court cases that are out there that upheld a 20% limitation. So what happens to them? Okay, because traditionally what happens is, when a circuit court decides a case, that becomes precedent and it binds the lower courts within that circuit. And so a district court can't typically just go overturn what a circuit court has done, because it doesn't have that power. The circuit court's word controls. So the plaintiff's attorneys are likely going to argue, at least in our circuit, that Rafferty still controls the 20% question. They may be able to argue to some success or to some ability to prevail, that at least when you're in Florida, Georgia, and Alabama, the trial court can't just step away from Rafferty because Rafferty is the law of the circuit. So we have to be prepared to challenge whether Rafferty is still valid. There's a lot of reasons to think that it shouldn't be. Number one is that the Department of Labor, used the same logic and all this sub-regulatory guidance that then made its way through and became the foundation for this rule. And the Fifth Circuit has very clearly said that that doesn't work at the regulatory level when it's an actual regulation that's been subject to notice and comment rulemaking. So if it doesn't work for that, which should ordinarily get more deference, then why should it work for the sub-regulatory guidance? And why should that be considered to be consistent with the statute itself? The problem is you may have to get the 11th Circuit itself to say that. And how are we going to get it to do that? We may have to get a district court case where a district court says, look, I have serious doubts as to whether Rafferty is still good law. I'm going to stay this. I'm going to certify this question up to the 11th Circuit so that they can review it. So this is a challenge, right? This is going to take some good lawyering to get the 11th Circuit to say, look, Rafferty is basically a zombie opinion now. Its logic doesn't really hold up, and this is not where we would go. Rafferty itself had, at least a dissent from Judge Luck, who's one of the current 11th Circuit judges, or at least a concurrence in which he said, look, this really is not the right approach, and this is not the way we should be interpreting this because it takes the focus off of occupation and puts it on the timesheet. And so Judge Luck foresaw exactly where the Fifth Circuit was going to go. We now have a more conservative 11th Circuit. We've had some new judges appointed there. There's a chance we can get this turned around there. But actually, it would be helpful if the Fifth Circuit case got appealed to the Supreme Court and if the Supreme Court took it. Because if it did, the Supreme Court's opinion, if it comes down against the 2021 rule, that conceivably could serve as the signal that the 11th Circuit case, the 8th Circuit case, and the 9th Circuit case are no longer good law. So that's kind of what we need, is we need to get it to the Supreme Court so that we have them saying this is bad law, or we're going to have to get it to the 11th Circuit and get the 11th Circuit to turn it around. So at this point, what does that mean for you guys, right? Because that's all fun for the lawyers to talk about as to how we get Rafferty overturned. But what does it mean if I'm trying to run my business? Well, here's what I would probably advise you. Number one is wait to see how this plays out further before you make any big changes. Don't assume that plaintiffs' lawyers are going to stop filing these cases right away. I think they may file less of them. They're certainly going to try to get what they can out of the cases they have already filed. They may be more inclined to settle those and see if they can get the bird in the hand. So they may be more amenable to a reasonable settlement now because they have the risk that a court, ultimately, takes this all out from underneath them in the near future. So I think they're going to be inclined to be a little bit more reasonable. We need to be aggressive in defending the cases that have already been filed. We need to see if we can get, the right judge at the district court level, the federal system, to get one of these cases up to the 11th Circuit so the 11th Circuit can take a second look at this. Okay. And we'll have to figure out how to do that as lawyers, but we need, you all to work with us as clients to figure out if this is the right case. Okay. Because some of us are stuck in the state court system with cases brought under the Florida version of the statute. And it's going to be hard to get those because those don't get reviewed by the 11th Circuit. Those get reviewed, if at all, by the Florida Supreme Court or by the Second District Court of Appeal in the state system. It's much harder to get those reviewed when they're in the state system. So if you're stuck on one of those cases in the state system with us, have a little patience with us because it may be harder to get a state judge to disregard this than it would be to get a federal judge to disregard this. But does this really change anything for us in the long term? I was talking about this with someone recently, and one of my points was, listen, you may be surprised how little this actually changes in the way the restaurant industry runs, because the 80-20 rule itself has always been a solution in search of a problem, okay? We were never going to have our servers spend massive amounts of time doing side work because then they're not being servers for us. They're not taking care of our customers. They're not selling menu items. Okay, so reasonable amounts of side work, fine. But if we just go and impose massive amounts of side work, our servers will leave us and they'll go to the next person down the street who gives them a better, approach to side work, and something that's more reasonable where they can make more money. So the market itself limits how we are going to attempt to make some of these changes. I think the big change is we'll probably sleep better at night, knowing that we have a chance at facing fewer of these big collective actions, that hopefully in the near future, we won't be subject to the folks like Grossman going around doing these one-offs where they try to get $5,000 settlements out of you. We have a lot better negotiating position right now. Okay. And I think you don't have to worry about any extreme positions you may have taken to try to get rid of, the 30-minute problem. But for right now, take a conservative approach to the 20% limitation. Recognize we kind of need to wait and see what happens either at the Supreme Court level or what happens in this next election cycle to see if anybody's going to try to resurrect it and bring it back from the dead. But assuming that none of that happens, I think we'll be in a position within a year, maybe two at the outside, where we'll have even clarity. We can say, look, we don't have to worry about 20%. We just need to make sure that the types of things we're having our servers do are traditional tipped or non-tipped duties that are part of the occupation of server. Okay. So I wouldn't go back and immediately start assigning servers to work in, checking the restroom or cleaning the restroom. You know why? Because the dual jobs regulation itself remains untouched. That is still valid. And it still says you can't pay the tip credit rate for work that's not part of a tipped occupation. And because DOL has taken the position that checking bathrooms and cleaning bathrooms and cleaning vent hoods in the kitchen and cleaning walls or windows outside are things that aren't related to the occupation of server, you still should not be having people do that at a tip credit rate. So that's kind of where we are as a practical matter. And I will now open it up for questions if anyone wants to discuss some questions.
And please feel free to put your questions in the Q&A box. Type them into the question and answer box. And Kevin can answer those. I don't see any at the moment. Give everybody.
Hopefully that means everyone's all got it figured out.
Okay. Well, someone said that this has been incredibly helpful and you've done a great job. And we have another comment that says, this looks like a very positive development in our industry. Ashley, we've had a question about when the recording will be live.
Hopefully later on this afternoon. I'll share it with all the attendees that are registered, and we'll have it on our website as well.
And Kevin, we had a question about, so your server cannot clean the restroom
Yes.
and side work. Is
Yeah,
that
that's
correct?
something I would put definitely on the check this right now category. If your side work list has checking or cleaning restrooms, you should take that off. Assign that to a manager, assign that to somebody who's not working at a tip credit rate. Okay, it can be somebody who is, a cook. It could be a busser who's working at full minimum wage or above, but don't have a tipped credit server be checking or cleaning restrooms.
Okay, it says, how does this apply if the server assists with side work, then due to weather, et cetera, the decision is made to let someone leave without taking tables? So
That's
they were
great.
supposed to
Great
come
question.
in.
This is one of the things that they talked about is the issue of idle time, right? So, should idle time count towards the 20% or not? And the Fifth Circuit was very critical of the DOL's position on this. Historically, as an industry, we've always kind of said, look, idle time is just part of the job. It's not necessarily the same thing as, being asked to do a whole bunch of side work. But the DOL in the latest rule said idle time should be counted towards the 20% limitation. This is a situation where I think I would be a little bit more aggressive here and say that if you've got an ordinary idle time, and here's the way to look at it, right? let's say you're a dinner restaurant, you open for dinner at 5 o'clock. Your servers are there, you have your openers ready to go, and you've got 3 servers ready to take tables at 5 o'clock. And at 5 o'clock, you get the normal Florida thunderstorm, and it rains cats and dogs for an hour. So nobody wants to come in until 6 o'clock. But you've got those servers there just in case, you get a whole busload of people that dash in and you have to have people handle those tables. I would say that is part of the occupation of being a server. That is reasonable to pay them at the tip credit rate. But you got to understand DOL might be different on that. So you would have the question of, if you want to be super safe, if you have a situation like that, are you better off putting them on some sort of utility or training rate, something like that for the hour or so until you actually get customers in the restaurant? That would be safer to do it that way. But if you want to just treat that as idle time and keep them on tip credit, I don't think that's going to happen enough where it's going to be worthy of justifying a lawsuit. You're talking about something that happens in pretty limited circumstances. Question about polishing flatware. Yes, I think if you're talking about ordinary, rolling and polishing of silverware, that is classic server side work. That is something that's within the occupation of a server, and I would be fine with that remaining part of a server's side work. Okay, and so question about support staff. And so if you are paying out tips, here's a really important point, right? These limitations all stem from the fact that we are paying our cash wages at the sub-minimum tip credit rate, okay? So tip pools are a different thing, right? Because some of you will have a tip pool where you give money out to, let's say, a host or a busser, and they share in some of the tips from the night, but they might not be paid at the tip credit rate. They might be making full minimum wage plus a share of the tip pool. If that's the case, if they're being paid full minimum wage as their rate, you can have them check the restrooms, okay? It's only when they're being paid at that sub-minimum tip credit rate, then you don't want them anywhere near the restrooms. So checking and replacing paper products, this is always where we get into trouble, right? Because everyone says, well, my side work is they're just supposed to glance in there, maybe restock the paper towels, maybe wipe the sink. If there's anything worse than that, if somebody pooped on the floor, they got to call a manager. Okay. And that's been the thing that we've all done for a long, long time. That's where it came from. But of course, when the plaintiff's lawyer gets a hold of it, the plaintiff's lawyer has them testify, no, we had to go in there and I had to go take the mop. And anytime there was something, on the floor, I had to go engage in all this janitorial work. And so the lies immediately put you in a situation where you have a question of fact. And that's why I tell my clients, I don't want your servers even opening the door to the restroom at our direction if they're on a tip credit rate. Have somebody who's being paid full minimum wage do that. It is too risky. It is too easy for them to lie about what they were really being asked to do. And the Department of Labor has been very clear on saying that checking and cleaning restrooms is unrelated work. Yeah, and the question about if you bump them to the full minimum wage before the storm, absolutely. You could sit there and have them roll silver. You could have them do anything you want if they're at full minimum wage. You could do training. You could have them go, do inventory or restock stuff. You could have them sweep. You could have them, clean the mats in the back of the house. It doesn't matter because they're no longer at the tip credit rate. Okay. Question on the FDA junk fee ruling. No, this isn't going to directly relate to that. All right. It is the lack of Chevron deference now is going to make it much harder for agencies to kind of create their own way of doing things. They are going to have to work through notice and comment rulemaking to pass regulations, but their regulations themselves are going to have to match up with what the language is in the statute. They can't just take a totally different viewpoint and make it happen through a regulation. Okay, setting up a wait station to get us open. Yeah, that's probably opening side work, right? So if I have opening side work that is, let's go ahead and get the coffee made and the tea made and get some stuff ready to go, cut the first round of lemons and make sure we've got all the caddies out on the tables, that's normal side work. That's fine. Okay. In the ordinary course and scope, you wouldn't want people doing that, to the point where it could conceivably result in more than 20% of their work week getting spent on it, at least until we get a little farther down the road with getting Rafferty off the books and with getting maybe the Supreme Court to really rule on this. But for now, I think normal side work is okay. I would just say, let's try to keep it to a point where we can argue that we don't have a problem. And I think this also means that the folks that do the big collective actions are going to be less likely to invest in them because they take so long to get through the courts. So that's a much riskier investment than one of these rinky-dink little, one-off cases that Grossman files. So our risk is primarily on those, because if they continue to file those little one-off cases, then, you might get dragged into one of those. And you're looking at me saying, well, I thought said you could get this to the 11th Circuit. I can tell you, look, I'd be happy to get it there for you if I can. If we can get them to accept it, you would be the hero for the industry. But what we're talking about is probably a $50,000 to $100,000 investment. And this is a case you could probably settle for $5,000. And at that point, some of you are going to think twice about being a hero for the industry and say, well, I am kind of on a tight margin here. So I really maybe am going to think better about that. And then maybe that's something we have to think about at the FRLA level. Okay, is there a way that we as an industry can pick a couple good cases and maybe get some support together to try to get them to the 11th Circuit as quickly as possible? And that's something we can talk about behind the scenes and see if that's a good way for us to get this cleaned up. And we will certainly have those conversations. Okay, and here's the question. What if the servers are making $50 to $60 an hour once you figure out what they make in tips all night, but they still have idle time in the beginning of the shift? This is kind of our fundamental problem, is we know what the servers make at the end of the night, right? And it amounts to $50 or $60 an hour. But from the standpoint of the Department of Labor, we're not responsible for that $50 to $60 an hour. The only thing we've been responsible for is the $8.98, which is going up to $9.98 in another month here, right? And then the $3.02 credit we can take against their tips. So from DOL's standpoint, any server who's paid the tip credit rate is a minimum wage employee, even if they make $60 a night per hour at the end of the day, okay? So that's why we have to be careful, is because if we're going to use that tip credit rate, under their old way of doing things, we couldn't get past 20% on side work or those related duties. So for now, I would say you have a little bit more freedom. You could have them just sit tight and just, basically, just have that idle time and stay on the tip credit rate at the start of their shift. Because like we said, how often is that going to happen? Maybe once, twice, 3 or 4 times a year where that's really a problem. So if that's what you're talking about, that's probably not enough to draw a lawsuit, assuming you do everything else right. But if that happens on a regular basis, where servers have a lot of idle time, because you're not scheduling them to when they actually get tables, or you're telling them, get there an hour early, before we actually have tables, that would be more problematic. And that's something where you are more likely to draw a lawsuit if it's happening on a daily basis. Yeah, so in layman's terms, that's right. If they're at the 898 doing their normal duties, that can include both serving and side work. And you don't have to have a separate clock in for side work at the $12 rate if you're comfortable with the direction these cases are going, right? What a lot of us had done over the last couple of years was to say, we're going to take our opening side work and our closing side work, and we're going to put that at the $12 rate, because that's what saves us from getting sued by the plaintiff's lawyers, right? Because we know if we have opening side work and closing side work at full minimum wage, then we're not really a good target for them. That saves us from those little rinky-dink lawsuits. Now, we ultimately think we can win some of these lawsuits, and we may not have to do that much longer. But again, like we said, we're trying to get through, and we're trying to get either a Supreme Court opinion, or we're trying to get the 11th Circuit to back off on Rafferty. Okay, fast casual restaurants where employees don't take tables, but they get tipped. So there's nothing in the tip credit rules that says they only apply to casual dining. There are some fast casual restaurants that may use a tipped wage. But again, you need to be very careful that you get that designed well if you're going to do that, and make sure that the people who participate and who are paid that tipped wage are all folks that have customer interaction. So if you have folks that work the register and then also run trays out to servers with what they've ordered, those people have the classic customer interaction. and they could probably be tipped employees. But if you're somebody that's sitting behind the counter and your job is just to make up salads or to check what's coming from the back of the house before it goes on the tray, and your back is to the customer the whole time, I got a lot of questions about how you're going to say that's a person with customer interaction. And I don't think you can pay them the tip credit rate. So you really need to talk to a good lawyer about that and have that well designed. And again, you need to think about where the tips go. Okay, because the big question is if you are going to mandate tip pooling and you're going to say that the servers have to share the tips and you start sharing them with back of the house people, then you may have a whole separate problem, which is you may have an invalid tip pool and you might not be able to take the tip credit for that reason. So be very, very careful that the only people that are receiving tips from a mandatory pool are people who have customer interaction and are classic tipped employees. So that generally means servers, hosts, bussers, okay, people like that. Maybe food runners, if you have a food runner position. Where you get in trouble potentially, and where sort of the dividing line is what people call expo. Your expo, again, is somebody who spends their entire time sitting at the window with their back to customers, not talking to customers, just handing plates to servers and making sure that the tray is put together correctly. That's probably not somebody who should be receiving tips. Okay. And if you were running a voluntary tip pool where you're encouraging servers to voluntarily tip back of the house, please be very, very careful with that. Those are very hard to sustain. I've been through one of those. How are you going to show that each new server consented to that? Okay. So be very careful. Can the tips be paid in payroll? Absolutely, they can. A lot of us have started doing that because they're coming in, 90 to 95% through credit cards. And so many folks have moved to paying those on a 2-week basis in with their payroll. You do have to think about, how are you going to, run your tip pool, and maybe your tip pool also gets paid out at the end of that 2-week basis, but you're going to have to track it and have the records to show how that worked. All right, that's a lot to take in. So if any of you have questions and feel like, there's more to this, I'm happy to talk about it further, just so, we have it up on the screen again or hear it again. My email is kjohnson@johnsonjackson.com. My phone number is 813-580-8400. All right, here's another question. If somebody is a takeout order and they leave a tip, can it go to the back of the house? All right, so if that tip is not going to any server, you're not taking it out of a server's pocket, you can decide where it goes, right? But anytime a tip is going to the back of the house, you run a risk, right? You run a risk of somebody coming in and saying that should have been my tip, and instead they took it away from me and they just sent it 100% to the back of the house. So you have to think about, is there somebody, some server somewhere who's going to say, I took that order, that should have been my tip? Or maybe a bartender who took that order over the phone says, that should have been my tip, and they took it away from me and gave it all to the back of the house. Now, that'd be different now if, for example, it was something where maybe you did a huge catering order, okay, and somebody left you a tip, right? And, it was to the house, it was not to any specific server, and you felt like you wanted to distribute that in some different way. We could think about it. But again, anything that we do that's too different from these basic rules, we're going to have to spend a lot of time defending it, and it creates greater compliance risks. So be careful with it.
Kevin, on behalf of the association, on behalf of Carol, she has been on the webinar and listening, and she says, thank you so much. Just want to say thank you for your knowledge, your experience, for being able to break this down and explain to our members everything that's going on in this regulation and where we're headed. This is a huge help to us. Thank you for sharing your contact information to the membership out there. Definitely, we give our wholehearted gratitude and endorsement to Kevin. You should follow up with him if you are in need of specific services for your business on this issue. So thank you, Kevin, so much for sharing your contact information. As Ashley said, this webinar will be live as soon as possible. We encourage you to share it with your other colleagues in the industry. And Kevin, we look forward to as this case progresses. And if we have new news, hope that you'll come back and give us the update.
Will do. Thank you so much.
Thank you.